Ministerial statement, Minister for Home Affairs and Law, Mr. Shanmugam.
Thank you, sir, for allowing me to speak on this. So in March 2019, Ms. Parti Liyani, and I'll refer to her as Ms. Liyani, was convicted in the state courts on 4 theft-related charges. She was sentenced to 26 months imprisonment. She appealed to the High Court against her conviction and sentence, and on the 4th of September 2020, she was acquitted on all the charges by the High Court. A number of questions have been raised following her acquittal. They center around how did the police and AGC handle the case, how should the state court judgment be assessed given the High Court's view. These are important questions. There has been much attention on this case. Members have filed questions, many news reports and commentaries on this since September. There has been interest because underlying these questions, which are specific to the case, there is a broader, more fundamental question. Did a powerful man, Mr. Liew Mun Leong, and I'll refer to him as LML, work the system to his advantage? Did the police and AGC unfairly prosecute Ms. Liyani because LML was a complainant? Did Ms. Liyani get a fair trial in the state courts? Do we have one law for the wealthy, socially connected, and another for the rest of society? This fundamental issue is at the heart of many of the questions that have been raised. And that question is of central importance to us. The credibility of our system, the foundation of our society, depends on us ensuring that there is rule of law and the law applies equally to all. If that principle is compromised, then Singapore is compromised. It is a basic duty of the government to ensure that that principle is upheld, and I take it very seriously. And so it is good that we deal with this, with the questions that have been asked. I will start first with the case, the investigations, the conduct of trial, and the specific questions which have arisen relating to the case. That will be part 1 of my statement. I will then move on to part 2, which will deal with the fundamental questions as I have put them. And in part 3, I will deal with the questions that MPs have raised. May I suggest 2 things? It's not going to be a short speech. And at the end of part 1, it may be appropriate to take a break and then come back for part 2 and 3. And we might, yes. At the end of part 1, certainly by end of part 3, we will probably know what's happening in the US. Let me start with the facts. The facts are as follows. Ms. Liyani was an Indonesian domestic worker working in Singapore since 1997. According to her, LML was her 3rd employer, but MOM records show that LML was in fact her 7th employer. She worked for LML from March of 2007 until 28th of October 2016. Her employment was terminated on that day. In court, the following was said, and I'm setting out what was said, not commenting on whether it is true or false. Over the years, the family's possessions went missing. LML gave examples such as a bag he bought from Tokyo, his jogging shoes, a number of Longchamp bags. He suspected Ms. Liyani of stealing, but did not take action as he could not be sure. A specially designed power bank from France that was gifted to LML disappeared a few days after he received it. Subsequent investigations show that this may have happened in May of 2016. By then, the only occupants in the house were LML, his wife Ng Lai Peng, whom I will refer to as NLP, and Ms. Liani. Though some others may have had access to the house, LML then decided to terminate Ms. Liani's employment. In this context, and I should add, and I will come back to this later, subsequent investigations also show that earlier in late 2015, the Liews were looking to replace Ms. Liani because they thought she was stealing things, but no firm decision was taken. In September 2016, they decided to terminate her employment and told the maid agency. Once a replacement helper was available, they decided to let Ms. Liani go. LML was traveling. He told his wife to arrange for people to be around and serve the notice of termination. On the 28th of October 2016, at about 11 a.m., Carl Liew, I'll refer to him as Carl, LML's son, went to LML's residence at 49 CL with employment agents, and this was at LML's request. Carl told Ms. Liani they were sending her back. No reasons were initially given. Ms. Liani asked for reasons. Carl told her that there are missing items in the house, and the only people staying in the house were my father, my mother, and you. She was asked to pack her belongings and given 2 months' salary as compensation in addition to that month's salary. Ms. Liani asked for boxes to pack her things. These were provided to her. She packed them with some assistance from the Liews' other employees. She sealed one box with tape and wrote her address on it. The other 2 boxes were sealed by 2 other employees of LML. Carl agreed to pay for the boxes to be sent back to Indonesia. Ms. Liani left the house with the employment agent and returned to Indonesia that night. The replacement helper commenced employment at LML's house on the same day, 28th of October 2016. When he got home, Carl told his wife, Heather Lim, and I'll refer to her as Heather, about what had happened. Heather told him that the boxes should not be sent back without knowing what was inside them. On the 29th of October 2016 in the afternoon, NLP, Carl, and Heather opened the boxes. They said they found items which belonged to them, which they had not seen for years. They spent about 2 hours going through the items. They also took a 21-second video. LML returned to Singapore sometime on 29 October 2016. He spent a short time going through the contents of the boxes. And on the 30th of October 2016, at 3:54 p.m., LML lodged a police report at Tanglin Police Station. On the 4th of November 2016, a police gazette was issued. I will come back to this later and deal with the police gazette. On the 2nd of December 2016, at about 9 p.m., Ms. Liani returned to Singapore. She was arrested at the airport based on the PG. Ms. Liani said in her statement to the police that she came back to visit a friend and go sightseeing thereafter, and she planned to return to Indonesia before going to Hong Kong to work. Later in court, she said that she in fact returned to Singapore to look for her agent and seek employment. When she was arrested, some items were found on her. These are listed in Annex 1, Table A to my statement, which will be distributed later. There is only one annex before members. That's a different annex. The others are outside. I think in the interest of time, we won't distribute each annex as I go through. The Liews said these were also stolen items. These items were seized and subsequently included in the charges against her. I will now deal with how the investigations were conducted by the police, how AGC assessed the case, and proceeded. LML had lodged a police report, as I said earlier, on the 30th of October. The police report stated that over the years, the family's belongings had gone missing. They suspected Ms. Liani. They terminated her employment on the 28th of October, and they found some of the items packed in her boxes. LML's statement was then taken. Initial investigation showed that Ms. Liani had left Singapore on the 28th of October itself. LML had set out in his police statement the items which he said had been stolen. The items were, according to LML, found amongst Ms. Liani's belongings in the boxes. Theft is an arrestable offense. Police needed to trace Ms. Liani to investigate further. Where there is reason to suspect that an arrestable offense has been committed, police will try to find the alleged offender and, if appropriate, arrest the person. If the person is at a known address, the police can go and interview the person. If there is no known address, or if the person is believed to have gone overseas, then a PG will be issued. And so a PG was issued in this case. Ms. Liani was believed to have gone overseas. On the 2nd of December, at about 9 p.m., as I said earlier, she was arrested at the airport. On the 3rd of December, police went to Liew's house or houses. They first went to Carl's house. One of the 3 boxes had been moved there. Carl told the police the items in the box were his. Police were told that the box containing Carl's items had been brought back to his home. The box contained an assortment of items: clothing, bedding, kitchenware, utensils. Items were taken out, laid out, photographed. These photos were used in recording the various statements taken subsequently. The physical items were not seized. Police then visited LML's house. Police were told that the 2 boxes had remained there. NLP recovered some items from the boxes: jewelry, accessories, watches, Gucci sunglasses. Police seized 51 items. 21 items eventually formed the 3rd charge. They were said to belong to LML's daughter, Ms. May Liew, and I'll refer to her as May. And these items are set out at Annex 2. Police did not seize all the items. They were seen as daily use items. The Liews claimed these items. Photographs were taken in lieu of seizure. Items found in those boxes are set out in Annex 1, Table B. Police then continued their investigations. They took statements from Ms. Liani, the Liews, and other witnesses. The matter was then referred to AGC. I will now set out how AGC proceeded in coming to the charging decision. When AGC receives a file from a law enforcement agency, the prosecutors will assess whether a charge is appropriate and what action, if any, should be taken. The assessment and decision are usually cleared by a director. Files are typically cleared at the director level, not usually brought up to a higher management, by which I mean the deputy chief prosecutor, the chief prosecutor, deputy attorney general, or attorney general, unless they involve more serious or sensitive crimes, or where the AG's consent to prosecute is expressly required. Ms. Liani's case was no different. It went through the same routine, and the charging decision was cleared at the director level. The events leading up to the charging decision were as follows. On the 5th of June 2017, police sent the file to AGC with their investigation findings and recommendations. Such theft files are routine matters handled by AGC. Over the last 3 years, AGC has dealt with an average about 3,000 reports every year for theft in dwelling and theft as servant offenses. The file was reviewed by 2 DPPs. They asked the police to investigate a number of further points. The police did that and returned the file to AGC with further findings. DPPs then reviewed the file. They sought further clarifications, and the file was then sent back to police for further investigations. Police conducted further investigations, then they sent the file back to AGC. DPPs reviewed the evidence again. This back and forth between police and AGC is again normal. In many cases, DPPs will look at the material and ask further questions. And because of the system in AGC, depending on which officer is on duty, it would be different DPPs who look at the same file. And that's what happened here as well. From the police and AGC perspective, this was handled as a routine theft case. There was no attempt by anyone to influence them. Police report was filed, and the matter was dealt with as such reports are usually dealt with. I will come back to this. AGC decided to charge Ms. Liani the 2 main reasons. There was sufficient evidence which showed that theft offenses were likely to have been committed. And second, it was in the public interest to prosecute. And let me explain this. The evidence before the AGC at the time was as follows. The Liews had identified all the items in the charges as items belonging to them and gave some detail. In contrast, based on what AGC saw, Ms. Liani gave answers which raised many questions. I will highlight some of these. Ms. Liani claimed that she had found some jewelry in May's trash. May stated that she never threw jewelry away. She would give unwanted jewelry to Salvation Army or friends. AGC's assessment was that the evidence of May was more believable. Ms. Liani also claimed that she had found items such as a Prada bag, 2 Apple iPhones, a pair of Gucci sunglasses in the trash. AGC did not find this to be credible. The list of items that Ms. Liani said she found in the trash are at NX3, and those are the photographs that have been circulated to members. Ms. Liani also expressly admitted to taking some items, 10 to 15 items of clothing, and let me explain this. In her first statement dated 3rd of December 2016, Ms. Liani was asked how she came into possession of male clothing. She said the clothing belonged to her employer. She said she took the clothing because the clothes were small. She assumed her employer's son, Carl, would not want the clothes. She did not ask Carl whether she could take the clothes. She admitted to taking the pieces of male clothing in early 2015. In her second statement, dated 4th of December 2016, Ms. Liani said, I only took about 10 to 15 pieces of men's clothing belonging to my employer's husband. I admit that I took it without informing my employer or her husband. And she also said, I only admit to taking the 10 to 15 men's clothing belonging to my employer's husband without consent, and I did not steal any other items. Her statement that she did not steal any other items is also very significant. Prima facie on the statements, this would appear to be theft. AGC assessed the case based on this and other material. I should add that under cross-examination in court, Ms. Liani said she was only given permission to take these items if Carl did not want them, but she did not ask Carl, meaning she just took the items. Ms. Liani also gave contradictory accounts to the police on several other items. These inconsistencies are set out in Annex 4. I will highlight 2 instances of inconsistencies as illustrations. A Vacheron Constantin watch and a Swatch watch. In her statement dated 4th of December, Ms. Liani said these watches were gifts from a friend. However, in a later statement of 29 May 2017, she said she found these watches in May's trash. A pair of Gucci sunglasses. In her statement dated 4th of December 2016, she said this was a gift from LML's previous helper. In a later statement of May 2017, she said she found it in her room at LML's home when she first started working for LML. I should add, later in court, Ms. Liani was asked about these contradictions. She gave explanations. Her explanations are also set out in the table at Annex 4. Putting together Ms. Liani's apparent inconsistencies, her answers on the jewelry and the other items, which she said she found in the trash, like the Prada bag, the 2 Apple iPhones, a pair of Gucci sunglasses, her other questionable answers, her admission to taking some male clothing without permission, AGC's view was that there was a case to prosecute. At that stage, the Liew's position was that the items were theirs. AGC also took the view that there was a clear public interest in prosecuting Ms. Liani. 2 reasons. One, it appeared that Ms. Liani had stolen many items, including some seemingly expensive items. And 2, it appeared that she had been stealing for years, and it was not impulsive, spur-of-the-moment decision. So the question for members in this House, in this case, is, on what I have set out, what material evidence did police and AGC have? What does that show? Was there a basis for AGC's view that the case ought to be prosecuted? That is why I have set out this material in some detail so that members can assess for themselves the basis for the decisions that police and AGC came to. I'll now move on to the trial. The trial was heard in the state courts over 20 days, from the 23rd of April 2018 to 17th of January 2019. The DPPs who conducted the trial were different from the DPPs who had previously been involved in the charging process. Ms. Liani was represented by counsel assigned under the Criminal Legal Aid Scheme or CLAS for both the trial and the appeal. I will come back later to CLAS. Let me now turn to the state court judgment. The trial judge found serious inconsistencies in Ms. Liani's evidence between what she said in court and her previous statements. The state court noted that Ms. Liani had various versions in relation to specific items. Ms. Liani said different things in her statement compared with what she said in evidence in chief in court, and then sometimes changed her version under cross-examination. I've earlier referred to Annex 4, which sets out these inconsistencies, and also her explanations for these inconsistencies. The state court found Ms. Liani's evidence on some items to be implausible. For example, the 2 old white iPhones. She said she picked up the 2 phones from a rubbish bag. These were iPhone 4 models, probably about 6 years old as of 2016. The state court preferred the Liew's evidence that they would not discard old mobile phones as they were used as spare phones or as hard drives to keep photographs. Jewelry, Ms. Liani said that most of the jewelry was picked from May's rubbish in 2011 or 2012, and she did not seek permission to take them. May identified the items as hers and provided circumstances of how and why she purchased them. The state court preferred May's version as it was more detailed and she came across as honest and forthright. Ms. Liani said a purple Prada bag and Gucci sunglasses with red stains were found in a rubbish bag. The state court accepted Heather's evidence that these items were never discarded. The trial judge said the modus operandi of Ms. Liani was to take variety of items from different family members, thinking that this would go unnoticed. On appeal, the High Court acquitted Ms. Liani on all charges. The High Court's decision was premised on 2 key findings. First, there was reasonable doubt as to whether the Liews had an improper motive for making allegations against Ms. Liani. Second, there had been a break in the chain of custody of the items which were said to have been stolen. In addition, the High Court also expressed doubts about the credibility of the prosecution witnesses, in particular Carl. It also expressed doubts on the extent to which Ms. Liani's statements given to the police should be used against her. I will deal with all 4 points. I should say this, as a rule, we don't comment in detail on court decisions. Sometimes we deal with specific issues that can arise from decisions or comments, and when decisions raise broader questions, then this House has discussed the relevant judgments, like the City Harvest case. In this case, the High Court's comments have given rise to the questions I have referred to earlier. These questions require us to go back and carefully analyze the judgment. It's difficult to discuss the law enforcement and legal processes here in Parliament based on the High Court's comments without a proper understanding of the comments. We also cannot make an assessment of whether the comments require us to change any of our current processes without looking carefully at the relevant parts of the judgment. So I will therefore be looking at parts of the High Court judgment to give the government's views on them, and based on that, I will set out what gaps there were in the investigations, conduct of the trial, and also say what more could or should have been done. But as we do this, let me make 3 points clear and reiterate what I had said earlier. First, the High Court decision is final. On the acquittal, there is no appeal. Second, I'm making no comment as to whether the High Court's decision can be relied upon or whether the judge's comments can be re-looked at in other proceedings. For example, in any proceedings that Ms. Liani or others are or may be involved, there are rules of evidence relating to these matters. Third, in this case, we have had to deal with the questions raised whether there are any systemic issues with our law enforcement processes, and for that purpose, we have to discuss the judgment, the government's view, and also look at some additional factual material, which we came to know of after the judgment was delivered. It's therefore a narrow, specific purpose. This exercise is not one of reopening the judgment. And I should emphasize that we are going into detail only because it is necessary for the purposes I have explained. So let's start with first the motive point. The judge said at paragraph 52 of the judgment, and I quote, The police report was made just 2 days after Parti made explicit to 2 members of Liew's family of her intention to lodge a complaint to the MOM about being required to work illegally at Carl's residence at 39 CL and at Carl's office. There are 2 points here. First, did Ms. Liani steal? And second, what was the Liew's motive in making the allegations? If it is shown that there is a reasonable doubt that the Liews had an improper motive, then what they say about Ms. Liani and the theft of items could become questionable. In this case, the High Court came to a view on motive that there was reasonable doubt as to whether the Liews filed the police report to prevent Ms. Liani from filing a MOM complaint against them for having deployed her to work outside their house. Motive appears to have been a key factor in the judgment, and we have looked carefully at what the High Court said at paragraph 52 of its judgment, that Ms. Liani had made explicit to 2 members of LML's family her intention to lodge a complaint to the MOM about being required to work illegally at Carl's residence at 39 CL and at Carl's office. The evidence is that as Ms. Liani was packing her things on the 28th of October 2016, she said she was going to complain to MOM. She didn't say what she was going to complain to MOM about. The High Court did note this and said that Ms. Liani did not actually say that she was going to complain about having been made to work at Carl's house or office. Thus, when the High Court said Ms. Liani had made explicit to 2 members of the Liew family she was going to complain about having been made to work outside LML's house, the statement was an inference the High Court has made based on the evidence and submissions before it. Based on this, the High Court also said LML and Carl must have been concerned, and therefore there is reasonable doubt as to whether they had a motive to make allegations and a police report against Ms. Liani. The court, in fact, said this threat by Ms. Liani on the 28th of October to lodge a complaint with MOM was, I quote, most critical, close quotes. Second, the court then said the Liews filed the urgent police report on 30th of October 2016 to ensure that Ms. Liani's return would be prevented and so that Ms. Liani cannot file a complaint to MOM. Third, the court said that the termination of her employment was sudden so that Ms. Liani would not have time to complain to MOM. I will deal with all these 3 observations that the court made because it is these observations on the Liew's motive which have primarily led to questions in this case on whether there was any improper influence by LML on the agencies, which is the question centrally before us. When Ms. Liani said on the 28th of October 2016 that she was going to complain to MOM, what was she referring to? Annex 5 sets out what Ms. Liani seems to have said, and this is based on subsequent investigations. The subsequent evidence is that she said, and I quote, "I want to complain because you gave me too short notice." She does seem to have actually said more than what is in evidence in court. Annex 5 also sets out why this part of what she said was not in evidence in the state courts, and I'll come back to this later. How and why was this subsequent evidence obtained? After the High Court decision was issued, there were internal reviews as announced. AGC also directed the police to conduct further investigations into whether any offenses had been committed by the Liews. This information that I've set out and other information was obtained in the course of those investigations which arose from the High Court's decision. So I emphasize that. As a result of the High Court comments, further investigations were conducted against the Liews. It was in the course of those investigations that this information came out. As stated earlier, the evidence is that LML had been thinking of terminating Ms. Liani's employment for some time prior to October 2016 because he suspected Ms. Liani of stealing. He told NLP of this. The further investigations conducted after the High Court decision show that NLP told the maid agency by end of 2015 that she wanted to get a new helper. She told the maid agency that she suspected Ms. Liani of stealing. She went to the agency a few times to review biodata of possible replacement helpers, but NLP did not make a firm decision. Sometime after LML received the power bank in May of 2016, it disappeared. LML then decided to terminate Ms. Liani's employment and told NLP. NLP visited the agency in September 2016 and chose a replacement helper. Ms. Liani was dismissed on 28th of October 2016 because a new helper had become available on that day. According to LML, he had agreed with NLP that Ms. Liani would only be dismissed once a replacement was found. Based on what the maid agent has said to the police, the new helper arrived in Singapore on 25th of October 2016. On 26th of October 2016, after checking with the maid agent on the status of the new helper, the family decided that Ms. Liani would be dismissed on 28 October 2016. On 28 October 2016, after Ms. Liani was told that her employment was terminated, Ms. Liani said, "I want to complain because you gave me too short notice." One of the maid agents who was present then confirms this. He says after Ms. Liani was told that her employment was terminated, Ms. Liani shouted that she wanted to complain to MOM about the short notice of termination. Ms. Liani did not say that she wanted to complain to MOM about anything else. As can be seen, this is quite different from the inference that the High Court had made. But the High Court understandably and naturally went on the basis of the evidence and the submissions made to it. The High Court didn't have the benefit of this additional evidence. And as I've said, our purpose is not to reopen the High Court's findings. Further investigation also revealed that on the 28th of October 2016, the maid agents offered twice to assist Ms. Liani with lodging an MOM complaint, but Ms. Liani declined. The first time was at 49 CL, when Ms. Liani first said that she wanted to complain. And the second time was at the agent's office before they left for airport. Ms. Liani declined on both occasions. Ms. Liani lodged her complaint about illegal deployment after she was charged in September and October of 2017. As can be seen from Annex 5, the prosecution did not obtain or put forward this evidence because the issue had not been raised by the defense in its case for defense or at the pre-trial conference. These points were thus not inquired into. Prosecution in general puts forward the evidence it needs for the charges and to deal with the points that the defense says it is going to make or raise. When a new point gets raised during the trial, prosecution will have to assess how to proceed. In this case, the matter was raised when witnesses were on the stand and in submissions. The prosecution did not see a need to deal with the issue by bringing in new evidence for the reasons set out in Annex 5. Annex 5 is a note prepared by AGC. I asked them to give me a note setting out how this point on motive was handled in court and the position that AGC took. I want to emphasize a few points. How a trial is handled, what evidence is led, is a matter for the lawyers involved to decide. I have myself been in such situations when the other side raises a new point. Do you deal with it by going back and checking if there is further evidence, or do you treat it as irrelevant, or do you deal with it in submissions? Really depends on the situation and the facts, the counsel's assessment. So we are not here discussing the specifics of how the trial was conducted and whether how it was conducted was right or wrong. My task before this House is to set out what happened, what we have found out since the High Court judgment, and based on that, examine whether there are any systemic issues and whether there was any influence peddling. I also emphasize members must take this further evidence in its proper context. It is evidence untested in court. But since this has come up during the further investigations as to whether the Liews committed an offense, I am duty-bound to set this out in this House because it is in my possession. So I cannot come here and go through the facts without telling you that we have this further information, which only came about because of further investigations into the Liews conduct was directed by AGC. I will now deal with the second point that the High Court made, that the Liews filed the police report to try and prevent Ms. Liani from making an MOM complaint. Making a police report will not prevent Ms. Liani from returning to Singapore. The High Court made the same point to defense counsel during the hearing. Indeed, in this case, it didn't stop her from returning to Singapore. And making a police report will also not prevent Ms. Liani from filing a complaint with MOM if she was serious about doing so. She does not even have to be in Singapore to do that. If a MOM complaint was a key concern, filing a police report and having police investigations is possibly a sure way for such complaint to be raised. Should Ms. Liani attempt to return, police investigations would also require her to remain in Singapore, once again offering her further opportunity to pursue an MOM complaint against the Liews. The High Court has also said that LML's reasons for filing the police report were curious. LML had stated that he was lodging the police report for record purposes, as he was afraid that her boyfriends might cause a nuisance or break into his apartment. Looking at it in this house, Ms. Liani had left and had asked for 3 boxes to be sent to her. The Liews had opened the boxes and were not going to send them to her. They said they found items belonging to them in the boxes. They also say they were concerned that Ms. Liani's boyfriends in Singapore might try to retrieve the items. In the circumstances, is it understandable that a police report is filed? Is it possible to think that Ms. Liani or persons acting on her behalf will ask what happened to the items and may accuse the Liews? I put forward these points on filing the police report because for our purposes in this context, the question is not whether the High Court is right or wrong, but rather the question is, how did the AGC and police proceed? Is there anything so obviously wrong about the filing of the police report that should have been apparent to the police and AGC? On the material before them, did the police and AGC have good reason to proceed on the basis that this was a routine theft case? That is the central question. Not whether the High Court was right, wrong, state court, who says what. Did AGC and police proceed in good faith based on the material before them? And what was before them? So I'm putting these points across so that members can place themselves in the shoes of police and AGC and think of these points. And it is for the same reason that I will go through some of the other points, which I will come to, but I may not keep repeating these points about why I'm going into detail, but as long as members understand the purpose of much of what I've said and will say, the detail that I'm setting out is broadly to help understand what was the basis on which police and agency proceeded in this case. Did they have good reason to proceed? What did they know before the trial? And we are looking at that to see whether systematically or systemically anything was wrong. The third point that the High Court made relates to the termination of Ms. Liani's employment. The High Court said the termination of Ms. Liani's employment was sudden, since there was no evidence of items that had gone missing in the period around 28th of October 2016, which necessitated the immediate and sudden termination of Ms. Liani's employment when LML was overseas. Thus, the High Court said this sudden termination was less likely to be because of items that went missing over the years and more likely to be due to fear of Ms. Liani's complaint to MOM. I have set out the way this point came up and how this point had been dealt with in evidence at the trial and what subsequent investigations show. The investigations show that the decision to terminate Ms. Liani's employment was not sudden. It was being considered from late 2015. The Liews decided upon a replacement helper in September 2016 for the reasons set out earlier. Ms. Liani's employment was terminated on the 28th of October 2016 because a replacement helper became available then. Police didn't go into this earlier. There was no reason for the police to believe that the termination was for reasons other than the alleged theft. I will now deal with a couple more points on the motive issue. The High Court used different terminologies to describe the Liew's motive. It said reason to believe, it said reasonable doubt, it said an improper motive, it said the improper motive, it referred to the existence of an improper motive. So it's not clear, was there only a reasonable doubt that the Liews had an improper motive, or is the court saying the Liews actually in fact had an improper motive? Because it cannot be both. Lawyers will know that. I think it will be a fair assumption that the High Court intended to say that there was a reasonable doubt and not that in fact it found that there was an improper motive. It means the High Court says there is a reasonable doubt as to whether the Liews had an improper motive and not that they in fact had an improper motive. The High Court also rejected the allegation that the whole of the Liew family were acting in collusion based on an improper motive. This view on motive appears to have considerably influenced the High Court in assessing the witness's credibility as well. The High Court said this at various points in the judgment. So that's the first reason why Ms. Liani was acquitted. I'll now come to the second reason, the second major reason for the High Court acquitting Ms. Liani. High Court said there was a break in the chain of custody of items which were alleged to have been stolen by Ms. Liani. Items which were recovered from the boxes are set out in Annex 1, Table B. The items which were recovered from Ms. Liani upon her arrest are set out in Annex 1, Table A. The break in the chain of custody applies to items recovered from the boxes and not the items seized from Ms. Liani. When you refer to the items in the boxes, I've set out the facts earlier. High Court found that there had been a break in the chain of the items from 29 October 2016, when they were found in the boxes by the Liews, to the 3rd of December 2016, when police visited the scene. The Liews were also using the items in the boxes during this period. The High Court therefore said the case of theft is not proven because it can't be proven that Ms. Liani took them. There could have been interference when the boxes were with the Liews. These items can be categorized into two categories, or classified into two categories. One, items which Ms. Liani admitted to packing in the boxes or otherwise admitted to taking. Two, items which she did not specifically admit to packing into her boxes. Where Ms. Liani admitted to packing the items or taking the items, then it really doesn't matter whether there was a chain of custody or whether that chain of custody was broken, because she clearly intended to take these items. Where she admits to packing the items or taking the items, then the only question is whether it belongs to the Liews or to Ms. Liani, or for some reason she's entitled to keep the items. We have identified the items which Ms. Liani does not admit to packing into her boxes, namely the 2 DVD players, some of the clothing said to belong to Carl, and 3 bed sheets and 1 blanket said to belong to Carl. Looking at the facts, the High Court's view that there was a break in the chain of custody is understandable in respect of these items. The fourth charge relates to items in Heather's possession, comprised solely of items seized from Ms. Liani, including a Prada bag and a pair of Gucci sunglasses with red stains when she came back from Jakarta. The break in chain of custody does not apply to these items. I've gone through this break in chain of custody in some detail because this was the second major reason the judge gave, but more importantly, because it relates directly to what the police did or did not do. For members' understanding, it is useful to know which items are affected by the break in the chain, which items are not so affected, and that several items are not affected by the break in the chain. This is because there has been a misunderstanding among some that all the items are affected by the break in the chain of custody. We have set out at Annex 6 how the issue of chain of custody affected the various items in the charges. If we remove those items possibly affected by the break in chain of custody, there would still be 4 theft charges against Ms. Liani. As regards the items that were affected by the break in the chain, there is no question the police should have acted faster. Police admit that there was a lapse in this area of investigation, and I will come back to this later. Third, the Liew's credibility. The High Court spoke about this. High Court had doubts about the Liew's credibility. In particular, it highlighted Carl's evidence. It noted the following points about Carl's evidence. 1, Carl did not clearly identify some pieces of clothing in the second charge, such as a black dress, as having been in his possession. Carl also had difficulties with some of the other items of clothing, like a cream polo t-shirt and a red blouse. High Court found Carl's claim that he wore women's t-shirts suspect. I'm using the High Court's words. Carl testified that a Gucci wallet and a brown buffalo wallet belonged to him and were gifts from his family. However, none of his family members could recall gifting him those specific items. High Court disbelieved his evidence, thought he was being untruthful. High Court disbelieved that a Helix watch was a gift from LML. That was Carl's evidence. LML denied having owned such an item. Carl agreed that a pink knife that he had earlier said he had purchased before 2002 was likely manufactured after that date. High Court said this affected Carl's credibility and his claim to ownership. High Court disbelieved Carl's evidence that he had bought a Habitat bedsheet in the UK from Habitat, and that High Court said he had fabricated his testimony. I quote, fabricated his testimony. The bedsheet had the same pattern as a quilt cover, which had an IKEA label. Carl's wife, Heather, also testified that she had never seen the bedsheet in her room or on her bed. Gerald Junta watch. Carl said initially the value was $25,000. Defense expert put the then current value at $500, given its state a chronograph pusher was missing, date malfunctioned, and the strap needed replacing. There are two issues here: whether Carl's evidence can be relied upon to convict Ms. Liani, and two, whether Carl was being dishonest. The High Court chose to give little weight to what he said and said he was unreliable. Given that Ms. Liani's liberty was at stake, I think many lawyers will understand that the whole of Carl's evidence was disregarded, as the High Court did. The second point was Carl being dishonest. The High Court thought so. Arising from this case, and it's an important statement of policy, Attorney General's Chambers has decided that hereafter, if any judgment or decision issued in the course of any legal proceedings contains findings that there may have been perjury or other serious offenses, AGC will seriously consider whether there should be further investigations, proceedings in respect of those indicated offenses. Carl has been investigated as to whether he committed any criminal offense, including perjury. Statements have been taken from Carl on the following points: whether the items highlighted by the High Court had been in his possession, his explanations for his inconsistencies during trial regarding these items. The investigations have been completed. A statement will be announced later this evening based on the investigations. Before I move on from the issue of credibility, let me say a few words about both Ms. Liani and the Liews. As I have said before, I am making these points to provide better context to deal with the questions that we are discussing and to better understand the basis on which the police and AGC proceeded. I want to be brief because there are ongoing investigations and proceedings. For the benefit of members, we have prepared a table which sets out the different items, the evidence, including the inconsistencies in evidence of both Ms. Liani and the Liews, and the explanations, the state court's views, and the High Court's views. This is set out at Annex 7. Broadly speaking, Ms. Liani gave a number of reasons for her inconsistent answers. One, she didn't understand the questions posed. Two, the interviewers didn't understand her answers or didn't record her answers accurately. For example, when she admitted to taking the 10 to 15 items of male clothing. Three, she meant to say something different from what was recorded in her statement. Four, she was shown unclear or blurry photos of some items, so she might have given the wrong answers because she couldn't recognize the items properly. Five, there was a black bag in her room which contained items left behind by the previous helper of the Liews, which the previous helper did not want, and the items from that bag may have been packed into the boxes inadvertently by those who were helping Ms. Liani to pack. And as for the Liews, Carl gave inconsistent answers in some areas, and in some instances, the testimony of one of the Liews was either contradicted or at variance with the evidence of another family member. There was some debate on the value of some items. An expert witness said that the Helix watch was of no value, and the Vacheron Constantin and the Swatch watches were counterfeit and had no value. This testimony was not directly contradicted. The defense also put in some articles on dumpster diving, suggesting expensive items like branded bags do get disposed of in the trash in Singapore, and thus Ms. Liani could have picked them up from the trash cans. The argument is that Ms. Liani could have found, for example, the Prada bag and the jewelry which May says were hers in the trash. There are various aspects of Ms. Liani's evidence which prima facie raise skepticism. There were inconsistencies in many of her answers. Answers changed from one statement to another, and from her statements to her evidence in court. Several aspects of her evidence in court also raise questions. Items which are said to be found in trash, for example, I will leave members to reach your own views. The police and AGC thought she was untruthful based on the police investigations. They assessed that she did steal, and that is why she was charged. I am giving you this summary to let you know how the police and AGC assessed the matter. And of course, when they did so, they did not have the benefit of her evidence in court. The state court found her to be quite untruthful. The High Court gave her the benefit of doubt because it was troubled by Carl's improbable, unreliable statements, some other inconsistencies in the Liew's testimonies, and their conduct, and for other reasons relating to the reliability of Ms. Liani's statements. If there were issues with the statement taking, then that affects the question of whether there were in fact inconsistencies in her statements. Moving on to the Liews, there are many aspects of Carl's conduct and evidence, some of which I have dealt with, which are highly unsatisfactory, which raise skepticism based on what he said at trial. He appeared not to be a credible witness. Filing a police report, making claims on items needs to be taken seriously. It doesn't have to be a comprehensive account, but it must be done with careful consideration. Looking at the evidence, the impression one gets is that there seems to have been a cavalier attitude on the part of the Liews in the way some items were identified as belonging to them and in the way values were ascribed to some items. It is natural to expect that you will know and take your duties seriously when you file a police report. Be careful in what you say and do, commensurate with your knowledge and experience. When you claim an item, you make sure it is yours. When you ascribe a value, make sure you have a basis. Questions do arise about how one or more of the Liews have conducted themselves on these and other aspects. I don't want to say more. There is more I would have liked to have said. I haven't made any comments about honesty. I have been somewhat restrained because of the investigations, and I've referred to a statement that will be issued tonight as a result of the investigations. In this context, again, the key issue for us is to go back to police and AGC. They had the statements from the prosecution witnesses. There was a prima facie case. They did not know that Carl or others would be inconsistent. The inconsistent evidence from Carl and other witnesses came at trial. That is not an unusual occurrence. It happens quite, I wouldn't say quite frequently, but not infrequently. It depends on the cross-examiner. It depends on how much they have thought about it and other reasons. But it happens often enough in civil cases as well as criminal cases. So there's nothing unusual about that either. I will now deal with the fourth reason given by the High Court in acquitting Ms. Liani. A total of 5 police statements were recorded from Ms. Liani. She gave the first 4 statements in Malay. She gave her 5th statement with the aid of a Bahasa Indonesia interpreter. Section 22(4) of the CPC requires a written statement to be read over to the person who gives it. This is usually done in English. When the person does not understand English, it must be read over in a language that he or she understands. The High Court found that there had been a breach of Section 22(4) of the CPC because Ms. Liani had not been given a Bahasa Indonesia interpreter for her first 4 statements. The High Court also said this was not a flagrant violation, so the statements remained admissible in court. They remained as evidence, though the court will decide what weight to give to it. In this case, the police officers believed in good faith that Ms. Liani understood Malay. She had worked in Singapore for over 20 years. The recorder asked Ms. Liani in Malay whether she wished to give her statement in Malay or in Bahasa Indonesia. She chose to speak in Malay. There is no significant difference between Malay and Bahasa Indonesia in the asking of that question. She did not ask for an interpreter during the recording of her statements. testified in court that he was able to communicate with her without any difficulties. The High Court recognized that she understood some Malay, though the extent of her understanding was unclear to the court. The High Court said that differences in the two languages could create reasonable doubt on the accuracy of the statements recorded. As I said earlier, the police believed in good faith that Ms. Liani understood Malay. And police accept there are differences between Bahasa Indonesia and our Malay, and in specific words, some words, they could mean different things even in the context of this case. And that can make a difference if Ms. Liani didn't know the different meanings. Section 22(4)(b) of CPC makes clear the key requirement is that the interviewee understands what is being said. A Bahasa Indonesia interpreter was provided in recording her final statement and when the charges were served on her. The final statement dealt with the majority of the areas covered in her previous statements recorded from Ms. Liani and the items in the charges that were tendered. So on that basis, her final statement is not affected by any issues relating to interpretation. At trial, Ms. Liani said that she may not have understood some aspects of the final statement because it was read back in a mixture of Malay and Bahasa Indonesia and that the interpreter was talking too fast. The High Court dismissed that claim. The statement reflected that it had been read back in Bahasa Indonesia and Ms. Liani had affirmed that to be correct and true. I will now, sir, deal with the specific issues that have been pointed out by the High Court in respect to the police investigations, AGC, and the state court judgment. I have earlier set out the facts that the police had after the investigations. It disclosed a prima facie case of theft. Police act in public interest. There are about 250,000 foreign domestic workers in Singapore, employed by more than 200,000 families. Where there's a complaint of theft, police need to be fair to both the employer and the domestic worker. Means police will have to investigate properly when there is a prima facie case and let AGC decide whether to prosecute. If, as a rule, police take no action, and if it is known that police won't take action, members can work out what the consequences will be for themselves. As in, you can think and work out the consequences, what such an approach will mean. We have to approach this with the perspective of both the 250,000 foreign domestic workers, to be fair to them, but also to the 200,000 families who employ them. If they believe that the employees have stolen or done something wrong, what are they supposed to do? It could be any one of these families. So we have to be very careful about how we deal with this. Police investigated about 66,200 criminal cases in 2016. And I'm referring to 2016 for illustrative purposes, and they were handled by about 1,100 IOs. Of the 66,200 cases, 14,122 were theft-related offenses in 2016. They resulted in 6,128 arrests. If we drill down to theft as a servant under Section 381 of the Penal Code, there were 500 arrests in 2016, of whom 246 were foreign domestic workers. So theft as servant cases involving foreign domestic workers, roughly 1 every 1.5 days, or 2 every 3 days. Of those 246 arrests, 58 were prosecuted, 24%. So 3 in 4 not prosecuted, 1 in 4 prosecuted. That who gets prosecuted is based on investigations and assessment by police and AGC, and also even when there is some case, but if it's not clear, sometimes warnings are given. I have explained earlier the reasons for the prosecution in this case. The case was handled by the police like they handle any routine theft case. It was handled by the IO and cleared by his immediate supervisor. I say IO when he was out, one or other IOs did handle it as well. but at the level of the investigation officer, cleared by his immediate supervisor. This was a routine matter cleared via normal channels. Matter was not considered or brought to the attention of anyone senior at any time, except that many of us came to know about it when it was reported in the media. I will come back to this later. So the question is, was there a clear prima facie case for the police to investigate? There was such a case. Police had a duty to investigate. If any member feels that police should not have investigated, I would be happy to hear and understand their perspective. The High Court commented on investigative processes, pointed out 3 aspects which it felt were deficient. I will deal with all 3. First, that there was a gap between the police report being filed on the 30th of October 2016 and the police looking at the items on 3 December 2016. The scene should have been visited by the police close to the time of the police report. This was a lapse which affected some but not all of the items in the charges. In terms of the acquittal, the High Court also acquitted Ms. Liani in respect to the items not affected by the break in the chain. So the break in itself may not have affected the outcome given the High Court's reasoning. However, there can be no excuse for this lapse on the part of the police officer. It is a breach of a legal requirement. It is also a breach of police protocol, both of which require the police to respond to a crime scene promptly or as soon as practicable. The broader objective of these requirements is to ensure the integrity of relevant evidence by securing it into police custody or otherwise obtaining a proper record of it. Whether there has to be a seizure in any specific case must depend on the facts of the case, the nature of the exhibits, and evidence. However, even if there is no seizure, it is necessary to obtain a proper record of the evidence, such as by careful photography of the items. In this case, careful photography soon after the police report was filed may have been good enough, but that was not done. I said there can be no excuse. I have nevertheless asked for an explanation as to why this has happened. I am told that the officer involved had a number of other ongoing cases, prosecutions, arrest operations, and a very personal matter that he had to deal with. He seems to have been under a lot of pressure. He was in a predicament. It was a situation that many home team officers find themselves in. It's a reality of what our officers go through. Nevertheless, internal investigations are being carried out in relation to the conduct of the officers involved in this case, and action will be taken as necessary. I must say, sir, I've noticed in various parts of the civil service, quite a lot of our officers are under work pressure. I've mentioned it at other points in this House. It's a general situation in some workplaces, many workplaces in Singapore with tight manpower issues, particularly several areas of the civil service. I have asked for a review of the workload of police investigation officers, though quite frankly, there is no easy solution because fundamentally it's a manpower issue. Technology has helped, will help, but that has limits. The police are also looking into online case management systems to prompt officers on next steps in investigative workflow and ensure accountability and minimize the risk of lapses in investigations. Next, I turn to photos. The second point that the High Court made about the police was a poor quality black and white photos were shown to Ms. Liani. Police agree that color photos would have been more effective. Color photos were shown to Ms. Liani in her final statement when a Bahasa Indonesia interpreter was also provided. Police will take on board the High Court's comments, which are fair. Police review has shown that the layout of the photographs was also not satisfactory. Some photos featured multiple items in a single photo with some overlapping and partially obscured. The third point the High Court made were the inaccuracies in recording the statements, the pace at which the questions were asked, and the time when one statement was taken. And thirdly, the provision of a Bahasa Indonesia interpreter. I have dealt with the interpretation issue earlier. On this issue, I have said to police officers, we need to make sure accused persons understand the statement recording process, what it involves, what is required of them. I've asked the police to ask what language the person wishes to speak, but also explain which they do, but also explain briefly what the process entails and the purpose of the statement, and that the accused may ask for an interpreter at any time, and that this should be recorded as part of the statement. The High Court also pointed out that there were inaccuracies in the way questions were phrased and there were grammatical errors. Police have said to me, it is difficult to make sure there are no grammatical errors, but I think everybody agrees they need to try and make sure grammatical errors, if any, should not affect the interpretation and understanding of the statement itself. Police accept the point made about time when statements are taken. Sometimes the timing is inevitable because of the legal requirement to release a person under investigation within 48 hours. Police will have to make an assessment on whether the person is capable of understanding the questions at the time the statements are taken. As I've said, police will take on the comments on board. The High Court also made observations about AGC on how the functionality of the DVD player was demonstrated in court. AGC has filed an affidavit explaining its position on record. The matter is now the subject of disciplinary proceedings, and thus I will refrain from commenting on this. I have been given a detailed note by AGC. I can set out the position, but I prefer not to. The disciplinary proceedings are by nature disciplinary. There are possible penal sanctions. There will be a full account of what the DPPs did at the DT. The key question before us is whether there was any improper influence on them. Minister Indrani has discussed this with Mr. Pritam Singh, leader of the opposition, who was also concerned that we should not go into this in Parliament. Let the DT handle it. The proceedings are penal in nature. I think lawyers will understand why we take this approach. AGC has also identified specific areas where it needs to improve. I will mention two areas. First, the valuation of items that are the subject of property offenses. In this case, the valuation of the items in the charges were derived from the Liew family's estimates. This has been the general practice hitherto, to rely on the complainant's assessment of the value. There are currently no formal guidelines for prosecution on the issue of valuation. Prosecutors are expected to use their judgment and discretion. AGC is developing guidelines on this issue. Independent assessment of the value of the items may have helped in respect of some of the items in this case. Second, AGC is also looking at how it prepares for trials, and it will seek to learn from this and other cases. There is a further but general and important point. Prosecution's overarching role is to ensure that justice is done and not to win the case at all costs. The point is not being made by reference to this case. It is a general point. AGC has consistently emphasized this point to all its officers and will continue to do so. The Attorney General himself has also publicly stressed his chamber's commitment to the principle of even-handed justice in his speeches at the opening of the legal year and elsewhere. Now I'll move to the High Court's view on the State Court judgment. First, some background on cases dealt with by state courts. State courts deal with most of the criminal cases in Singapore. The appeals go to the High Court. About 10% of the appeals succeed, for instance, in setting aside the convictions or reducing the sentence. Ms. Liani's case falls in that 10%. This 10% of cases, there can be different views on evidence, on law, the exigencies of trial process. Example, witnesses say different things, or something new turns up. The High Court disagreed with the trial judge's assessment of the evidence and made observations. With that as a background, I will say the views expressed by the High Court fall within the range of cases where an appellate court disagrees with a lower court. In some of these cases, the appellate court does take a different interpretation of the evidence, draws different inferences, comes to different conclusions. That is the function of the appellate court when it takes the view that the lower court has made an error. In 2018 and 2019, there were 16 appeals by the accused against conviction when the appellate court disagreed with the lower court and reversed the decision. 9 were appeals from the state courts to the High Court, and 7 were appeals from the High Court to the Court of Appeal. So even between the High Court and Court of Appeal, there are differences of view. For example, one of the cases, Muhammad Effendi, was chain of custody issue also arose. In another case, PP versus GCK 2020, the state court convicted the accused for outrage of modesty. He was sentenced to 22 months imprisonment, 3 strokes of the cane. The High Court reversed the conviction, acquitted the accused on the basis that there was insufficient evidence. On a criminal reference, the Court of Appeal reinstated the conviction but substituted the original sentence with a sentence of 16 months imprisonment and 3 strokes of the cane. So our state court one view, High Court different view, Court of Appeal a different view again. Question for us, as I've said more than once, is not which court was right or wrong. The key question was the case conducted fairly in both courts. The state court heard evidence from 12 prosecution witnesses, 4 defense witnesses, including Ms. Liani, over 20 days. It had the opportunity to observe the witnesses, consider the evidence, Ms. Liani's submissions, and it made its findings. The High Court considered the lower court's findings and Ms. Liani's further submissions over 3 days and came to a different view. This became a long and somewhat complex or complicated case. Record of proceedings runs to almost 3,700 pages. I have brought this House through some of the issues in detail, as I said earlier, to give members a slightly better appreciation of the evidence. The matter was thoroughly ventilated and considered by both the state courts and the High Court. It was one of those 10% of cases where the appeal court disagreed with the lower court. I've covered the points specific to the case. Let me now set out what happened in summary. 1, there was clear evidence for the police to investigate and for the AGC to prosecute this case. The police and AGC dealt with this case like they deal with other theft cases. There are questions about some aspects of one or more of the Liew's evidence and conduct, the claim of ownership of some items, and the valuation by them. That appears to have been quite cavalier, to say the least. Questions also arise about Ms. Liani's conduct and evidence. The High Court gave Ms. Liani the benefit of doubt because it was troubled by one or more of the Liew's evidence and conduct, and because there were questions relating to her statements. There are aspects of trial preparation where police and AGC can improve. Finally, the key point. There was nothing improper, nor any undue pressure on the police or AGC at any stage of these investigations and proceedings, and no evidence of any personal connection between the Liews and any police officer, DPP, judge involved in this case. I have gone through all of this because we have to show the police and the AGC did not act arbitrarily or as a result of the influence of a rich and influential family. Those were the accusations that circulated immediately after the learned Justice Chan issued his judgment, that there was a grave miscarriage of justice, and AGC and police were asked to apologize. What I put forward to this House show that the police and AGC had good grounds to charge Ms. Liani. They certainly did not act at the behest of the Liew family, and this is how our system is supposed to work. Police and AGC make up their assessments based on the evidence. The High Court disagreed, the State Court agreed with the prosecution and convicted Ms. Liani. The High Court disagreed, overturned the conviction, felt there were reasonable grounds to doubt the motives of the Liew family in making the police report. Again, this shows how our system works. The rest, so I will deal with in part 2. What I've said is the fundamental question relating to our systems. And I wonder, sir, if this is an appropriate time to take a break.
Sounds like it would be. Order. I propose to take a break now. Take the sitting at 4. 4:10 p.m. Order, order.